All rise and give your attention. The Honorable Justices of the Montana Supreme Court. This court is now in session.
Good morning. I think it would have been more appropriate to say something instead of all rise, you know, maybe going where no man has gone before, you know, something like that. I mean, there's no real reason to rise, but I guess that's what we do. It looks to me like we have everyone on. So this is cause number 190378, State of Montana versus John Mosby. Mr. Wright, I think it's your turn to go first.
Thank you, Your Honor. May it please the court, Chad Wright for John Mosby. How does the state drag John Mosby into court more than a decade after the criminal charges were dismissed and jurisdiction was transferred from the criminal to the civil commitment proceedings because he was unfit to proceed in the criminal proceedings? The answer has to be, if you follow Montana law, that you can't drag him back into the criminal court. The charges can't be resumed. They can't be recharged. They can't be, as the district court said, resurrected out of thin air. The plain language of 4614-221 speaks in terms of shall, dismissed, the disposition of the case, and suspended versus final dismissal. It prevents, as the state is trying to do here, an end run around the statutory procedure to prevent endless prosecutions in these civil commitment cases where the defendant was unfit to proceed in the criminal case. Where did things go wrong at this point? Where did they go wrong in this case? The original court did everything right to a point. Mosby was found unfit to proceed by a defense expert. He was 24 years old. He'd been institutionalized since birth. Dr. Scalati, the defense expert, said it was nearly impossible for John Mosby to meet the basic courtroom skills to synthesize facts and sequence them. So he was committed to the Montana Developmental Center for a lengthy evaluation and treatment process to try to regain competency. That's 4614-221 sub 2A. And at the end of that review period, Mosby was also found unfit to proceed by the state's own expert. Dr. Dean Gregg said Mosby had no rational understanding of the proceedings. He had an intellectual disability and he was unlikely to be fit in the future. The court, as it was required to do, followed the procedure at that point and reviewed the case. But the court didn't take action until the state moved to dismiss because he was unfit. And that's the underlying principle that maybe we don't want to lose sight of here, is that the due process clause in the 14th Amendment prohibits criminal prosecution of a defendant who's not competent to proceed, not competent to understand the trial that is presented to them. But what may have started the problem here back in 2006 is that the state snuck in this without prejudice phrase into the order that it submitted to the district court, that the district court signed off on. But under 4614-221, this dismissal was the final disposition of the criminal case. It was gone. It was gone. Dismissal,
Mr. Wright,
yes.
if I could interrupt you, if you could address 4614-222 in the context of 421.
Sure.
And I guess what's disturbing is that, you know, and this is a serious offense as well, but just take, for instance, a homicide. Are you suggesting that a defendant who's charged with homicide and after 90 days is presumed unfit to proceed can never be charged, even if they regain their fitness a month later? I mean, that's the natural extension of what you're suggesting.
No, I think there's a difference there, Judge. If you look at Tyson and Meeks, those were serious offenses too, and both those defendants regained fitness after the charges should have been dismissed. And I'm saying, no, you can't re-prosecute them even if they regain fitness. what we're saying here is that you need to trust the professionals in this position, and that somebody who could regain fitness in a month in a homicide case, you may take a longer period of time to evaluate them. And that's what they did after Meeks and Tyson. The hospital and other professionals involved in this realm have taken longer periods of time to say, let's extend the commitment here to see if we can make this person fit again. And Barris is the best example of that. I don't think we need to give hypotheticals. You all are familiar with State v. Barris. There was a place where the defendant was unfit to proceed, but the hospital felt that he could be medicated, and this court ruled that they could medicate him against his wishes. And they extended that time, medicating him, trying to make him fit for months and months and months. And then they became fit. And that's where 222 kicks in at that point. That's when the proceedings can be resumed. So there's plenty of time in serious cases where there's questions about the defendant's fitness, where there's ability to medicate, or whether there's an ability to somehow deal with a fitness problem sometime in the future that could be resolved to deal with that problem. And that's where 222 says you can resume the proceedings. I think the secondary question is, if it's a serious case, that person's not going to be released either. And that's what this court has always said. The mandatory procedures in 221 after the dismissal move to civil commitment, where somebody is in a secure facility, where they're being treatment, where they're not just out in the community walking around. And that's where you can address the seriousness of the underlying offense and consider the dangerousness of the offender at that stage.
Well, let's follow up on that a little bit. And Justice McKinnon's question, let's look at the Yarnell case, for example. In that case, I mean, I'm not sure Meeks and Tyson are right on point because they didn't involve 222. They involved failure to comply with 221. But let's say that the psychiatrist in Yarnell had come in and said to the court, you know, not only is he not fit now, but I'm not sure we can get him there in 6 months. I think this could be a long haul and we're not getting anywhere. The court would have had to dismiss under 221. And then a year later, he not only regains fitness, but no longer meets the criteria for civil commitment. What you're saying about how they're not going to be released on the streets, that assumes they meet all the criteria for continued civil commitments. So in that case, if Mr. Yarnell had no longer met the criteria and his charge had been dismissed, you're saying it would be barred. 222 does not use the word suspended. It uses the word resume. And under 4614-103, the statute says that a defendant, it's the policy of the state that a person not be tried while the incapacity endures. So looking at all of these together, how does it meet the goals of the statute to completely foreclose a prosecution for a serious offense if the person does regain that capacity?
Again, I think we have to, and maybe this is uncomfortable for lawyers, right, is we have to rely on the professionals at that point. So we're saying that if they were suffering from such a serious mental disability or illness, that they can't be prosecuted, and that it's unlikely that they're going to regain fitness anytime soon, we have to trust them that they can then go to a facility where they'll be treated or made safe sometime in the future. What the U.S. Supreme Court, though, has clearly said, and what our statutes were designed, and this court has said often to do, is to prevent the idea that somebody just remains in limbo for an extended period of time. That's why there's the 90-day time limit. That there are time limits built into the statute, so somebody doesn't just exist in limbo without getting their trial. That's what Jackson said. You wouldn't have gotten a trial, or without giving the opportunity to go forward in the case. So,
Mr. Wright,
oh, go ahead.
Excuse me. Why? So, and I get that, and that's why 221 requires the dismissal. But what in 222 forecloses a refiling? See, I think I draw a distinction between resumption of a suspended case and refiling of a dismissed case. I mean, what in 222 forecloses the refiling of a previously dismissed case?
I agree with you. There's a difference between resumption of a suspended case. So if you look at 2A, these statutes have to be read together. So if you look at 221 2A, that's the suspended portion of the case while they're trying to make the person fit. And then 222 kicks in. If they do make the person fit, you can resume the proceedings because it was suspended. But if it's dismissed, you don't resume something that's dismissed. That doesn't make sense.
Yeah, precisely. So that's my point here is there was not a resumption of a suspended prosecution. There was a refiling of a dismissed prosecution.
There was not, Your Honor, because there was no new information filed. He was not arraigned on new charges. The state specifically relied on 222 to say this was suspended for 11 years. We're just restarting. We're resurrecting is what the judge said. And
So under that theory though, right? I mean, let's say we decided the way you're talking, they could refile the case. And then what would the issue be?
well, if they refiled, I think the issue would be, does 221 allow a refiling of a case after it's dismissed? And I'm saying Jackson v. Indiana in those cases say no. And the plain language of this says no. Dismissal means dismissal. It's what you have said repeatedly over the years, that once the case is dismissed, both in Meeks and Tyson's, you say the state lacked authority to proceed anymore in the criminal case. So the civil case is all that remains. And that's the one where we have to rely on the professionals, that folks that are dangerous will remain in civil commitment until they're not.
But again, Meeks and Tyson are distinguishable to the extent that they involved failure to comply with 221 by dismissing after the 90 days when there was no reasonable prospect that the defendant would regain fitness. I mean, there's no question that there was a compliance with 221 and it has been dismissed. So I guess going back to Justice Gustafson's and my procedure and my question, procedurally, what if a case is dismissed pursuant to 221, then what in the language of 222 or any of this forecloses a refiling of a dismissed case? I mean, by analogy, let's assume for the sake of argument that this case was dismissed without prejudice because a key witness disappeared, and then that witness comes back. Is there, I mean, barring speedy trial or due process or statute of limitations, what would foreclose? I mean, those are all considerations, but that's not what we're talking about here. What would foreclose the refiling of a dismissed case without prejudice?
Well, I think what you're talking about is the plain language of the statute is dismissal. And so I don't think there's a distinction between a dismissal for failure to follow the statute or dismissal for complying with the statute. Both Meeks and Tyson.
Except for the statute is what mandated, and this is what we said in Tyson and Meeks, the statute mandated dismissal.
Right.
Failure to comply with 221. What I'm saying is if there is compliance with 221 as there was here, and there is a dismissal, and this explicitly said without prejudice, but let's say just for the sake of argument, it says dismissal, and I mean, you seem to be reading in with prejudice, and I'm trying to find where in 222 or 221 is there something that says that the dismissal is with prejudice or that it forecloses a refiling of a charge as opposed to a resumption of a suspended charge.
So I'll start with 221 first, right? The language of 3A is the defendant must be dismissed. The proceeding against the defendant must be dismissed. And so that's just the plain language. And so whether we're reading into without prejudice or with prejudice there, I think those are kind of magic terms that we don't need to use. The presumption is because the way you've read it is that proceeding is dismissed, criminal authority ceases to exist after 90 days when there's no reasonable likelihood of fitness being regained. That's the way the plain language of the statute's read. That's the way you've said since before Meeks and Tyson and Curtis. You've said that's the way the statute works. And so if you're correct, Your Honor, Meeks and Tyson could be re-prosecuted. It's not the violation of failure to file the statute. It's that the 90 days were up there and they could be re-prosecuted now. There'd be no end to the prosecution, right? There'd be nothing that would limit the ability at any time in the future for the prosecution to come back and recharge somebody if they gain fitness, like here, 11, 10 years down the line, or 15 or 20 years down the line. And that's exactly what Jackson v. Indiana said you can't do.
Mr. Wright, but that's not exactly, we've left out an important part of 222, which is that if the court is of the view that so much time has elapsed since the commitment of the defendant that it would be unjust to resume the criminal proceedings, then the court may dismiss the charge. So there is a check mechanism. And if we could look at that a little bit, I don't think the speedy trial application applies in this context if there has been a dismissal. I don't think, and you're primarily because of the Supreme Court decision US versus McDonald that said the Sixth Amendment speedy trial doesn't apply to a case where it's been dismissed and then recharged. But the 14th Amendment due process analysis applies, substantive due process. So if you could address what is it that the court should be looking at, what factors should the district judge be looking at when they're trying to decide whether it's just or not to allow that prosecution to go forward?
I think you have to look at the plain language of 222 if we move there. There's two types of commitment there. So it says since the commitment of the defendant that it would be unjust to resume the criminal proceeding. That commitment talks about the 2A commitment, the commitment trying to get the person fit and treated at the hospital. That's the Barris example we talked about. So what if you'd said, well, let's forcefully medicate Barris and give him enough time to get fit? Well, what if it'd been 5, 10, 15 years? I don't think I can set what you're asking, Justice McKinnon, about what sort of criteria do we give for the judges about how much time must be done there. But the distinction that really needs to be made is that's the proceeding before the case is dismissed. Because otherwise, if you read the statute here, is that you'd have a double dismissal, which just doesn't make sense, right? You would dismiss the case. You can't resume a case that's been dismissed. And then you'd have the ability to dismiss it again before it even goes forward. This only talks about dismissals when the person is actively being treated before the dismissal talks.
So are you saying then, I mean, under 222, that you get 90 days and then maybe you have a professional that says, well, I don't know, they may become fit in the next year. And then we just hold them for another year and then have another proceeding and the professional says, well, I don't know, we're trying a different medication. You might become fit on that one. It'll be another year. I mean, I understand you want to rely on the professionals for this, but how would you cut off then what's a reasonable time where it must be dismissed, right? Where this isn't hanging over their head. I mean, can a reasonable professional or a professional say, well, reasonably he could become fit in the next 20 years. So we'll just have him hang out here and we'll try different meds.
Well, Jackson v. Indiana addresses that directly, right? It says you can do this for extended time, but it also says in Jackson that there has to be some sort of proof towards the progress of the goal of fitness. So if there's no proof towards the progress of the goal, then I think Jackson and our statutes both say that it would have to be dismissed while you're in that treatment phase. And that's the check against that, is that proof of the idea towards the treatment of the goals.
So let me ask you this. Assuming you weren't applying these statutes. I mean, cases, it's not unusual that a case would be dismissed before the jury is called, and it gets refiled down the road. And the standard in that situation is the statute of limitations. So, you know, assuming that you don't have a double jeopardy issue, was dismissed earlier in the process, then you're really looking at a statute of limitations. So back to our homicide example, there isn't a statute of limitations, but there certainly is in this case.
Yes, I agree, and that's where sub 4 kicks in. There's always the idea that you could try to dismiss a case for any reason, but this is not like the general dismissal. 4614 or 4613-401, the general dismissal, which I think you're referring to, Your Honor, right? It's a normal case, and we just dismissed right before trial because some sort of defect in the information or some sort of lack of proof. We can't avoid this specific language of this case. And under a normal dismissal, Mosby would have been released right away. Under this dismissal, the state is required to seek to hold him in civil commitment proceedings. And so that's the difference between those two. And that's why you can't intermingle the ideas of a normal dismissal under 401 as opposed to the dismissals that are set out here to comply with Jackson and constitutional law about holding charges over people's head indefinitely.
Mr. Wright, I wanted to ask you about your second issue while we have a minute here on the credit for time served, assuming for now, if the court gets past your first argument, you've submitted some supplemental authority, including Chapter 283 from this last legislative session about including time spent in a residential treatment facility for credit for time served. And the only definition I could find of residential treatment facility was in the healthcare section 55101, which defines a residential treatment facility as a facility operated for the primary purpose of providing residential psychiatric care to individuals under 21 years of age. The MCDC, or the Montana Developmental Center, is defined in the term residential facility under 532102. So do you have any more information about what the legislature intended by residential treatment facility in that new code section?
I followed the enactment of this law. I know they weren't cross-referencing with the health codes about treatment facilities there. I think we just have to say plain language, a residential treatment facility. I think NDC is that, but I don't have any other cross-references within the statutes.
Okay.
And maybe that's a good jumping point off to talk about, even though I think this language is plain here, I think it's always good when we have legislative history that supports the plain reading of what I'm talking about with the dismissal. And the legislature said very explicitly when they enacted these changes, largely in relation to what Jackson v. Indiana was talking about, that it was only fair to dismiss after a certain period of time. And they didn't condition that dismissal on the severity or lack of severity of the crime, because you couldn't come up with a sliding scale about when you dismiss when there's a more serious crime, when you dismiss when it's a less serious crime. I just think it's nice that we have that same idea here. And it gives you that idea that the dismissal means that a dismissal that can't be recharged in the future, because otherwise there'd be no end to the prosecutions. There'd be nothing that would put sideboards on the state, as they've done here, to either try to say this is a resumption of the charge under 222, which doesn't make sense as you've come up today, or try to come up with a brand new charging reason to charge in the future when nothing has changed about the setup of the case. I don't have any more on that, or and haven't addressed the speedy trial argument. I will respond a little bit to Judge McKinnon's, that Jackson seems to indicate that there would be the ability to consider those, but those issues were not raised in Jackson v. Indiana.
Let me ask you another question then about 222. So the statute says when the court determines that the defendant has regained fitness, they must resume. So then it back to Judge McKinnon's question, but if the commitment in the appears to be unfair, so that's a discretionary issue in terms of the district judge. How do we address that? I'm still circling around back to the statute of limitations. I mean, it seems to me that the statute of limitations has run, that might be a way the court could consider abuse of discretion.
I would like to agree with that to a point, but 222 I have to maintain is not applicable here, because the commitment, and you can see the difference between the two commitments in that statute. There's the commitment that's the 2A commitment, the treatment commitment that we're talking about. And then if you dismiss, you go to the civil commitment. And what we're talking about in 222 is resuming something that has never been dismissed, that has always been ongoing.
But Mr. Wright, I understand that point, but get us to the next point, which is if we don't agree with you on that, we have to apply the language of 222.
Sure, okay. So if you don't agree and you think that 222 means that you can restart the prosecution, and you've got this double idea of you dismissed before, but the judge has some discretion to dismiss again here, then I think the language that you're talking about there is that so much time has elapsed that the defendant should be discharged, that there has to be something related to the underlying sentence, I guess would be right, or that somebody who's been committed, or as the judge said in this case, he was locked up in MDC for 11 and a half, 12 years here. And then you get to basically double that sentence. If you consider that a criminal sentence then, because you've resumed, it was part of the underlying proceeding. And you get to double that sentence by imposing another 50-year sentence on top of that. Those sorts of factors should be considered whether the court can dismiss the case at this point for the interests of justice. And you have other examples under 46-13-401 that talks about what the interest of justice means and how the judge can impose those criteria at that point. With that, I'll reserve my remaining time.
Mr. Wright, before you go, can you give me the citation of that Barris case that you referenced?
It was you all did the writ of supervisory control for the cell hearing. It was State versus Lloyd Barris. And there was a supervisory control for whether to forcefully medicate Mr. Barris or not. I don't have the citation, I'm sorry.
Was that cited in the briefs? Did I miss that?
No, I brought that up as an example because it seemed to fit with Judge McKinnon talking about the serious murder case and what it would do in a serious murder case, and the process would seem to work there.
And last thing on that, so I can try to track this down. Do you remember how his name was spelled?
I think it's 2 L's, L-L-O-Y-D, Barris, B-A-R-R-U-S.
Thank you.
Thank you.
Mr. Fowler.
May it please the court, my opposing counsel and members of the streaming audience, Mark Fowler for the state. The Montana fitness statutes to, that govern how to proceed do not bar recharging a defendant who has lost fitness to proceed, but then regains it after the state has dismissed the case voluntarily, reserving the right to pursue criminal charges in the future, as is indicated by the term without prejudice. The without prejudice determination was agreed to by Mr. Mosby's counsel and was incorporated in the order of the court, the trial court. It should be recalled that, Judge Deshaw is faced with a dire sort of immediate problem, because after the length of civil commitment, it had appeared that quite suddenly, frankly, to surprise of many, that Mr. Mosby was in fact fit to proceed and was seeking to get out of civil commitment. At that point, the state learned of his fitness to proceed and of course recalled that it had not dismissed the case, or understood the case was not dismissed by any adjudication on the underlying merits or factual predicate for the crime, as prosecutors are statutorily obligated to pursue charges against someone where there's unadjudicated criminal liability. That's when Judge Deshaw said that the state could renew the prosecution. I'd like to turn to.
But you didn't file a new petition or a new charging information, right? I mean,
That's correct.
How did we get there? It seems like it was dismissed. And if we assume it was dismissed without prejudice, the normal course is the state files a new charging document, correct?
That's correct.
And that didn't happen here.
Nope, it did not. And quite frankly, candid with the court, it should have. The overriding point the state wishes to make is that the state had the authority to pursue pursue adjudication on the merits of criminal liability through a new prosecution. The procedure pursued, admittedly, was not the proper one. It should have been, Your Honor is correct, the filing of a new information. I believe, however, that this court can affirm the conviction under its inherent authority to protect against the violation of substantial rights of litigants. If a new information was filed or were filed, in this case, as it should have been, we would be in the same situation here with the claims that Mr. Mosby is making. So I think that we can reach the result, if not for the correct procedure not being used.
But if you had done it that way, right? I mean, the normal things is then if you wait 10 years to rebring file a new information, then, back to Justice McKinnon's deal is that, the arguments then are that there was an unreasonable delay in prosecution and, that there are reasons why the case can't proceed. And those really would have been at the forefront instead of kind of what we're looking at now, correct?
Well, if I understand the concern, and Mr. Wright said the state has no sideboards to rein it in. I think that's incorrect entirely, because certainly speedy trial was raised. Chief Justice McGrath, I don't believe statute of limitations was raised, but I think that I can answer that if the court wishes. But there are appropriate means for a defendant to attack the renewal through a new information, such by those means, speedy trial delay. But I don't think 222 and the unfitness statutes are pertinent to that point, because 222 ultimately governs resumption of a pending criminal matter that has been suspended. As again, that's what Justice Shea had mentioned in his questioning. That is the view of the state. 222 does not effectuate, nor 221 effectuate the adjudication of criminal liability. If it were, it would say so. Your honors know, who have prosecuted cases and who have been trial judges, that the state often will dismiss voluntarily a case in which may have been the information may have been improvidently requested and entered and issued to refile the information at subsequent time when there is, for instance, additional criminal investigation materials discovery adduced. in fairness to the process of justice. So here, as what occurred was, Mr. Wright emphasizes that the case says the statutes, unfitness statutes, say dismissal, but they say so under the specific design and purpose of these statutes, which is primarily as a policy ground. We don't warehouse defendants who are unfit and who are not in a reasonably foreseeable future going to be found fit. That's what Jackson versus Indiana addresses.
Mr. Fowler, I want to talk to you about that for a minute. It seems to me that public policy doesn't have anything to do with any of this, nor does the state's compelling interest in prosecuting crime, which is unassailable. This is simply a statutory construction issue. And I don't understand how the state can say when 222 talks about resumption of a case and 221 has a process for suspending a case. Obviously, resumption of a suspended case makes logical sense by the plain language of these provisions. But a dismissal is a dismissal. So how do you resume a case that is no more and has been dismissed? And I think there's a focus here on the fact that the judge dismissed the case on the state's motion without prejudice. Where is any authority, either in the express language of these statutes or any case that we have ever considered, that allows a judge under 221 sub 3 to dismiss with prejudice as opposed to just a straight dismissal?
Your Honor, dismissal is not dismissal, frankly, and these statutes are not, they don't govern prosecutorial authority to pursue charges. That's independent of these statutes. The case on point with the independent authority would be the Fletcher case from 1996, Your Honors, which talk about the inherent and statutory authority of prosecutors to bring charges. But these statutes, I think, in addressing your question directly, Justice, is these statutes are unfitness to proceed statutes which hinge on a fundamental premise in the language of the statutes. Justice Baker had pointed out in subsection 103 that presumes that a prosecution will only last when there is a challenge to the fitness of the defendant, so long as the incapacity endures. So long as, I mean, that's a logical if-when statement. If it doesn't endure, in fact stops, then certainly the other statutes talk about resuming a prosecution which has been suspended. The prosecution.
But Mr. Fowler, there's a fundamental difference between a case that's suspended and therefore is subject to resumption and a case that's dismissed. And I don't have any qualms with the broad prosecutorial discretion of the state, but I don't see where 221 sub 3 at the point that there is a finding by the court which is implicitly what applied here, that this guy was still unfit after review. And the balance of that criteria for dismissal is that it's not likely, or whatever the language is, but it's not likely that he's going to be able to regain fitness anytime soon. Then dismissal. The legislature didn't say dismissal without prejudice. And there's a distinct difference between a dismissal and a dismissal without prejudice. And to me, this is a statutory issue, and I don't know how either the state or we can get around that.
Your Honor, 2 points to respond to your question. One, you asked for precedent. I would then respectfully direct your honors to your precedent governing res judicata about when an issue has been put in conflict that has been challenged. Here, these unfitness statutes don't talk about the underlying factual predicate of the crime. It has nothing to do with it.
Mr. Fowler, res judicata doesn't define the nature of a dismissal. So I don't see how that authority has any application here.
Yes, Your Honor, logically it does, because res judicata analysis requires a view of what happened in the earlier proceeding. These statutes, the unfitness statutes, unlike the insanity defense or mental disease or defect, which is found by a jury to relieve the defendant of criminal liability, unfitness does not relieve any defendant of criminal liability. What the thrust of the argument that you're directing me to answer, Your Honor, is that if there's been unfitness and unfitness doesn't appear to be remedied in any reasonable future time, and what we get is the dismissal because of delay is not, delay is unacceptable according to Jackson versus Indiana, and you have to go to civil commitment to treat the individual, then the defendant gets a free pass.
But Mr. Fowler, that's a public policy issue. It's up to whether the defendant should get a pass, whether it's free or not. That's up to the legislature. And so it's not for us to agree or disagree with that, or to plug holes in the statute or not. It's to apply the law as it's written. And I don't see how res judicata is in this. That language doesn't appear anywhere in the briefs, in the statute, or any relevant authority that I'm aware of.
Your Honor, I was posing res judicata as an analogy, as it's persuasive authority to understand what occurs when there's dismissal. You have to look at what was adjudicated. To that extent, Your Honor, then if that doesn't apply analogously, then you can refuse to consider it if you choose to. But the state agrees fundamentally, Your Honor, with your analysis regarding policy versus what the statute says, and what the legislature intended here in the unfitness statute was not to relieve someone who is unfit, which is really just the postponement of liability, to be completely off the hook. Nowhere in the statute does it reach that by the plain.
It does read that though, Mr. Fowler, because the legislature uses terms like suspension and resumption in one hand for one procedure that's provided, and upon a particular finding thereafter, it uses language dismissal, unqualified dismissal. So that's where the legislative intent is in its express language. And I don't think that it's ambiguous at all. But I'll quit haggling with you. I just wanted to give you a chance to respond to that, because that's how I see this. And you don't have to if you don't want to.
Well, no, one last argument. It appears that we may not agree on this point, but I would put to you that the design of these statutes in the overall area entitled of mental competence of the accused, clearly the legislature has spoken in other areas of the statute that govern mental disease or defect. Clearly, the finding of a jury that adjudicates that individual because of mental disease or defect, that relieves responsibility for the underlying criminal charges. Unfitness here is only a postponement of the liability. It's not, it doesn't require adjudication. Dismissal is not dismissal, as your honors know, who have been trial judges particularly, that granting a request by the state that specifically reserves the dismissal is without prejudice is allowable. And it was agreed to by Mr. Mosby.
But it doesn't matter what he agreed to. What I'm talking to you about is what the statute says. It says dismissal, an unqualified dismissal. It doesn't, the legislature doesn't authorize in its express language or contemplate a dismissal without prejudice on that finding under 221 sub 3, unless we read it out of whole cloth.
Your Honor, neither does the statute say it's dismissed as a final adjudication on the merits. I mean,
that's what a dismissal is, unless it's without prejudice. So that's the point.
Excuse me, is there a way, Mr. Fowler, you had said that 221 and 222 deal only with the mental health aspect of, and I guess another way of looking at it is 221 and 222 are a way of addressing both the mental health aspect as well as the criminal proceeding. And that the language of 222, when it talks about resume, I mean, you still have these two proceedings going forward. You've got the mental health proceeding and the criminal proceeding. And so, I mean, are we reading too much into resumed? I mean, in terms of the dismissal. I mean, we really have a way, we have a scheme here that tries to address incompetency in the context of a criminal case.
If I understand your question, Your Honor, may I provide this, that the statute here that talks about resumption is talking about a case which is pending, but suspended. It talks about resumption or no resumption based upon clear circumstances of two conditions. One, fitness regained or unfitness continues. I think that the thrust of the statute, clear legislative intent, is that, you know, fitness can be regained or it can continue, but there is an idea that at some point there is a clear, distinct possibility that fitness can be regained and the person can be tried. The state cannot try someone and convict them who is unfit. And so once the criminal prosecution has ended, the state must pursue civil commitment. It doesn't say at the same time. It says the case must be dismissed as criminal matter, and the state must resort to civil commitment, which is entirely non-punitive, non-criminal procedure. Then at that point, you know, civil commitments have their own independent protections that are invoked and used to protect Mr. Mosby, which occurred in this case. I don't believe I've answered your question.
No, you have. Then I also would like you to address the unjust aspect. What are the factors that should go into that consideration by the trial judge? In other words, let's say Mosby had been brought forward on a new information, and that issue was, well, it was, but when would it be unjust to have the case go forward?
I think that there are several claims that can be made for an accused to attack a new information, which would be unjust delay as a substantive due process matter, that there is authority that provides that sort of remedy. Statute of limitations, however, the statute of limitations, Your Honors, would be subject to tolling. That would be during the time for which the prosecution cannot pursue a new information. You can't. It would be improper for the prosecution to pursue a new information against someone they know or should know is not fit to even be tried. And of course, speedy trial, which was pursued in this matter too. I think all those things are present to affect how a prosecutor decides to renew a prosecution, if at all. And also, once being granted the information, it would go through the testing of a challenge based on those other remedies. So I think that there are sideboards. Mr. Wright has mentioned there are protections and remedies available to accused in situations such as this.
All right, so I don't think that a speedy trial Sixth Amendment application applies. So we're under the 14th Amendment. Now maybe we can draw from speedy trial considerations, but going forward, you know, what are some of the things that we should help instruct the district judges in terms of what factors are important? We can draw on that speedy trial analysis, but the Sixth Amendment doesn't apply when a case has been dismissed and then reinstated.
Well, if I understand your question and the concern you're expressing, obviously is the 11 years that occurred in this case. But I think what it must be borne in mind, and I think what judges in the future should know is, you know, was, for instance, there any evidence that the state was strategically seeking civil commitment to bring him to fitness? I mean, Mr. Wright argued that in what I believe respectfully was mischaracterization of the Jackson versus Indiana, which deals with a pending case and prolonged unfitness procedures being used over and over again. Here, civil commitment is civil. It's a civil remedy. It was not used. It can be used. Kansas versus Hendrix is an excellent case that explains that. It could be used potentially by a prosecutor in order to get the, you know, deliberately and purposely get the defendant found fit. That was not the purpose of civil commitment procedures for 11 years in this case. It was to treat his underlying severe developmental disability and his mental disorders. There is no indication that the prosecutor was waiting to restart the information as soon as there was unfitness, that it, in some way orchestrated through the civil commitment procedures. The civil commitment procedures were used non-retributively, not as a deterrence. Those are the two key features of what distinguishes a criminal proceeding and a civil proceeding. So to answer your question, I think this presents unique circumstances in this case for this court to rule. I think it may serve actually as an excellent case as a vehicle for the court to rule that the state is not restricted by any of the plain wording of the statute. Even Justice Jennifer, in respect to you, sir, it is unqualified, which means the legislature, I believe, intended that there could be circumstances in which, such as this case, the defendant is malingering, as he admitted, is in deliberately trying to avoid criminal liability because of his own manipulation of the processes, which he admitted to. And therefore, the prosecution has the statutory duty to bring the individual, this dangerous individual, to account.
Mr. Fowler, before you run out of time, I just want to ask if you have any comment on the defendant's submission of supplemental authority.
Supplemental authority does not apply because reading the statute as a whole, as now amended by the new Bill 451, you still have to take into consideration, your honors may not have it in front of you, the entire bill. It deals with a person incarcerated on a bailable offense. In that situation, then you have two, you would have conceivably two, let's say there is a civil commitment going on that's pending during the same time a criminal proceeding is pending. I think in that sense, it's understandable that the accused should have credit for that time served while in civil commitment, because the state is pursuing at the time criminal liability. That accused is under peril and is suffering, theoretically, the peril of a criminal prosecution at the same time. And then when that accused is convicted and is sentenced and given a period of incarceration, it is right and just that during that time for which criminal proceedings were pending for a bailable offense, that you account for the time spent in treatment, or as it does talk about a residential treatment facility. I would leave that to the court to apply whether or not that, to whether that applies to MDC or such. But I don't think that's the case. That's not the facts here. I don't think it applies to the facts here. He was given credit for time served. I don't think that statute weighs in on the conversation your honors and the state have had here about the fundamental purpose and the plain reading of the unfitness to proceed statutes. If there being no other questions, your honors, I would ask that the court be respectfully mindful of the situation with this defendant, who is assessed and perceived as chronically violent and a sexual predator early on. I mean, I don't want to belabor the point, but I think it's important to recognize situations such as this, where Mr. Mosby was assessed at borderline intellectual functioning, but it later determined that actually he was a lot smarter than his testing showed, because he had sought and learned to manipulate the processes. So in a way, we are seeing here in the manipulation and fitness to proceed statutes, in order to avoid criminal liability for acts. I think there is no unfairness to Mr. Mosby for the state to pursue prosecution in this instance, and ask that you affirm the judgment of the trial court. Thank you.
Counsel,
Yes.
I sure would hate for you to not use 5 minutes of your time. So I'll throw in a question I probably wouldn't normally throw in, but the research of the history of this statute which sort of explains to me how it got to be in the confusing state it is today. From 1967 to 1983, the language in 221 only referenced suspension. There was no reference to dismissal within the language of 221 during those many years. And that way it fit perfectly with 222 because 221 discussed the suspension of the proceeding, and then 222 discussed its possible dismissal. And that was the only place dismissal was mentioned. Then in 1983, the legislature passes a statute, which it said was to provide for the disposition of those defendants found unfit to proceed. And they dumped all the dismissal language that you now see in 221 in with one fell swoop into the statute that used to only address suspension. And they failed to address 222 at all or explain how the dismissal of 221 would fit with the dismissal language in 222. And it just seems to me that reaffirms that the dismissal language of 222 really only applies when there's a suspension, not when there is a prior dismissal of the proceeding. Any thoughts?
The state's position regarding to the pre-1983 version of the statute is that like the Indiana statute which was the basis of the Jackson versus Indiana, which stated there was an Indiana statute which stated that a person who was not fit to stand trial would be committed based on their incompetency, and they would remain committed until they regain fitness. I think the legislature in 1983 in our state changed the statute to require that case be dismissed if the person was not likely to regain fitness within a reasonable time, so they would not be committed long-term without a finding they met the requirements of civil commitment. I think that's what is, I think that those statutes and the statutory change serve the state's argument in this case, not against it. I think the legislature did not want to, I think the legislature contemplated the situation as we have here. A situation where it just was not at the beginning foreseeable that Mr. Mosby would receive sufficient treatment to have his fitness regained, but nevertheless, what does the state do in the meantime? It cannot continue to prosecute him, and we can't warehouse them just because of unfitness. The state must show and pursue a petition for civil commitment. That does not reach the fundamental issue, which I think that some members of the court have highlighted today in our discussion. What do you do about the underlying criminal liability? What do you do about the acts that were prosecuted but were halted because of this unfitness? I think the change and the taking out of the matters that Your Honor, Justice Brights has mentioned favor the state's view here that the very plain language of these statutes for fitness do not prohibit the renewal, not resumption. Resumption applies to postponement of a pending case. The renewal of charges that have never been adjudicated and the state is entitled, actually bound to pursue.
Thank you.
Last question, so we can use up all your time.
Very good.
And I realize this is not squarely in front of us, but when we're talking about the guardrails that are there, the protections, and we talk about the substantive due process and the statute of limitations, you had mentioned that the statute of limitations would be told during the period of commitment here. Is that correct?
Well, Your Honor, yes, and I don't have case precedent exactly to point to, Your Honors, but I believe that your jurisprudence governing speedy trial analysis does take into the situation where, for instance, the defendant absconds from the jurisdiction from the state. He is, a fugitive from justice. I think the state is not able to pursue a prosecution. Similarly here, where the person is presumably not fit to be taken to trial, at the same time as being civilly committed. I think that that type of tolling analysis should come into play. I think that there are legitimate arguments the state can make that that matter should not be held against state.
Just for clarification, you were referencing speedy trial. I'm talking about statutes of limitations.
Oh, sorry, Your Honor. I would think by analogous application, the same would hold true. I think that there is argument, colorable claims for the state to make that this person is not prosecutable. This person is beyond, while being civilly committed, this person is beyond the arm of the law. And therefore, I believe a tolling argument could be made. Of course, that has not, Mr. Mosby has not been given an opportunity.
Right. Okay, thank you.
Thank you, Your Honors.
I guess I'll go ahead and start again. I want to address the idea that somebody would malinger to end up in the Montana Developmental Center, which was not a great facility, or it'd still be open now for 11 years. So I think that idea is somewhat absurd. But I also want to address this first confusion here on section 222. I thought at the start of the state's argument that they said clearly 222 doesn't apply, that Mr. Mosby should have been recharged. There should have been a new information filed. And they made a mistake by not doing that in this case. If the state agrees that 222 doesn't apply, that we haven't resumed a criminal prosecution here, I don't understand how we can then use the second part of 222 to allow some sort of interest of justice exception for courts, district courts, to decide how that case goes forward or doesn't go forward. If 222 doesn't apply, then you do as this court has done for 30 years and said, this is the way this statute works, 221. And I'm citing Curtis, not Tyson and Meeks. I understand folks say there was some compliance problems with Tyson and Meeks, but before that, there was Curtis, where you said the language of 4614-221 sub 2 is clear, and the statute speaks for itself. It provides a mean for committing a defendant who's not fit for a limited period of time to determine whether that defendant will become fit to proceed to trial. If it appears that fitness to proceed will not occur within a reasonable foreseeable future, the criminal proceedings must be dismissed. And I think it's this last point that we're missing here. And the state must proceed under statutes authorizing appropriate treatment for the underlying mental condition. That's the transfer of jurisdiction that this court has always upheld up until, and not questioned at this point, is that dismissal meant dismissal, as Judge Sandifer said, because you had to transfer jurisdiction to a whole separate sort of proceeding that was non-criminal. And you can see other examples of this in your jurisprudence. The state cites State versus Asmundson, I think is how you pronounce it, where there a justice court said, hey, there's a 20-day time limit for the temporary order of protection, but I'm going to extend that time limit a little bit farther because you were filing a dissolution of marriage. And this court said, no, you lost jurisdiction to do that, and you can't go back and re-prosecute. And you did so because of the plain language of it, even though the defendant didn't challenge that jurisdiction, even though there was claims of waiver. And that's what we've got here, is that the defendant assumed, because he was told, that jurisdiction transferred to the civil court and that the criminal jurisdiction ended. And that's what this court has held for over 30 years.
So what is that case again that you just were talking about in the divorce area or order of protection?
State versus Amundsen is on page 22 of the state's brief.
Thank you.
It's 940 P. 2nd 104. And that's the difference here, is that dismissal triggers a whole separate process. And so now you're saying 11 years after the fact, you can come back and restart the criminal proceedings that were dismissed and to go to civil jurisdiction at that point. There's no authority within the statute to say that. There's no authority within your case law to say that you could do something.
But Mr. Wright, you can't keep the civil proceeding going indefinitely either, right?
That's absolutely true. And that was not done in this case, right? Because there was annual review of Mr. Mosby's condition. And that's what led here, right? To this point where, hey, wait a minute, maybe there's a point where we could release him at this point. And the state panics and comes in and tries to charge him criminally again on charges that had been just dismissed a decade ago.
But don't you think the requirement for the dismissal is in response to having a civil proceeding hanging, ongoing for so long? In other words, that's where not only the idea that you don't want to have a criminal trial hanging over your head while you're in a civil jurisdiction, commitment jurisdiction, but the fact that, that the civil case can go for a lot longer. It can go for a long period of time.
Well, maybe I'm not understanding the question. I think that's a good thing, right? Is that the civil case can go on as long as there are protections, and that's what Jackson v. Indiana says, as long as you've gone through the protections that the state has set up to see if somebody can be civilly committed. That's why we do have people that have committed homicides that are civilly committed for 20, 30 years or longer, right? We allow that because that's the way the statute's set up and that's the way the judicial process set up.
So then what's the purpose behind the dismissal section?
Well, that's what I'm saying. If there's no purpose, the way the state reads the statute behind the dismissal, because you can bring it up, is that sometime in the future, you could recharge those people with no restrictions.
But aren't the restrictions, as we alluded to before, and setting aside Mr. Fowler's tolling argument, which, you have statutes of limitations and you have substantive due process.
Well, but they didn't work.
I'm trying to understand, excuse me for one second, I'm just trying to understand why a dismissal that does not specify with or without prejudice, but which in this case, the court specifically designated as without prejudice, why that should be treated any differently than a dismissal that is for any other reason that is without prejudice. And if it's specifically delineated as such by the court and, is refiled. And again, drawing the distinction there between that and resuming a suspended prosecution, is refiled at some point whenever the infirmity is cured, whether that's missing witnesses or lab results or what have you. Why should this be treated this dismissal be presumed to be with prejudice once the infirmity is removed?
Because unlike those other dismissals, those people walk. If the lab results don't come in and it's dismissed with or without prejudice, that person walks out the jail door. Mr. Mosby goes over to Montana Developmental Center, right? Because it's required by statute that he has to be transferred, he has to be held. There's no other option. The prosecutor has to do that.
And he's not going to be held once the the infirmity is removed.
But the finding is, it's unlikely that the infirmity will be resolved in a short period of time. So you're rejecting the idea that the experts have said that it's unlikely he's going to be regain fitness within a reasonable future. And what happened here? 10, 11 years is what
it's not resolved within a short period of time, then that's when the statute of limitations, and this is where we have effectively something built into the other statutes that are the guardrails here. You have
it didn't
limitations,
work.
so we're not having to decide what's more serious and what's not. The statute of limitations have already decided that for us. Somebody who's determined to be unfit to proceed for a misdemeanor or for a minor felony, as opposed to something with a longer statute of limitations, like a sex offense or a homicide that has no statute of limitations. Those are the guardrails.
Well, but if that was true, then why was Mr. Mosby charged with the misdemeanor exposure violation here, right? He was charged with a misdemeanor and recharged with it. It was only dismissed as part of the plea agreement here. And so the protections that you say exist, Mr. Fowler just said they're not going to exist because we're going to say while he's in treatment, while he's being held against his will in the Montana Developmental Center, it's tolling. The time.
Well,
period
and I
is
get
tolling.
that, and I'm not saying I agree with that, though.
Yeah, well, that's the state's argument. That's what I'm saying. We've got the example that misdemeanor was recharged. I think it was presumed is what the state, they've never said recharged until today. And we've got the example of the state saying, we're going to try every way we can to get around anything that would protect the defendant from having this trial hanging over their head for extended period of time. And that's what's disconcerting to me today is what changed in the jurisprudence where we used to think that was an abhorrent idea. That's the language from Tyson, that it's abhorrent that we keep a criminal trial hanging over somebody's head for 10, 11 years. And today we don't think that, right?
Well, isn't a criminal trial hanging over somebody's head if a dismissal is without prejudice for another reason but for the statutes of limitations and substantive due process?
Yeah, absolutely. But that person gets to go to the grocery store and that person gets to drive their car around, have a job, all of those things. But Mr. Mosby has to go to the Montana Developmental Center and be locked up. I mean, that's what the district court said. That can't be disputed, right? That he was locked up for 11 years by statutory requirement. There was no other reason than the statute required that they have. It wasn't an independent determination made by the state saying, maybe we should look to commit him civilly. It was something that was required by the legislature to do. And that's the difference in the dismissals there. So I got 30 seconds left. I don't think I can add any more to that. I appreciate your time.
Well, thank you very much to both counsel. This has been a good argument and a good discussion. We appreciate you appearing before us on Zoom, and we will take this matter under advisement and issue an opinion in due course. Thank you.